Good afternoon, everyone. My name is Kathy Hale, and I am the Supervisor for Public Services at the State Library of Pennsylvania. The State Library of Pennsylvania is also the regional library for the Federal Depository Library Program, sponsored by the Government Publications Office. We are here today to celebrate U.S. Constitution Day. It is actually on the 17th of September, and it is to commemorate the signing and putting together of the U.S. Constitution back in 1787. There were 39 men who gathered at Philadelphia and hammered out our U.S. Constitution. 9 of those people were Pennsylvanians, including our friend Ben Franklin. Of course, he was into everything, so of course he would be on the U.S. Constitution. He is one of several men who signed both the Declaration of Independence and the U.S. Constitution. Today, we're going to welcome Patrick Lord. He works in the Pennsylvania Department of Education in the General Counsel's office, and he has been with the department for quite a number of years. Patrick and I ride the train together, so we've gotten to know each other a little bit more that way. Patrick is chiefly responsible for providing legal support with respect to transactional matters, including grants and procurement. And he's worked in a couple of different places, and you can read more about that on our events page. So, Patrick, without any further ado, we're going to hear you speak about education and the Constitution, a tour at the Schoolhouse Gate. Patrick, if you could take it away.
Okay. Thank you, Kathy, and good afternoon, everyone. I'm honored to speak to you today on Constitution Day. It's a particular honor to be invited to speak by the State Library, as the Supreme Court itself has described public libraries as places, quote, dedicated to quiet, to knowledge, and to beauty, close quote. I hope I can do justice to that noble sentiment. But before I begin the substance of my talk, I'd first like to give you a few disclaimers. First, my comments today reflect my personal opinions and should not be construed as voicing the opinion of the State Library, the Department of Education, the Office of General Counsel, or the Commonwealth. Second, my words should not be construed as providing legal advice. I'm covering an important topic and a lot of territory today. If you have a constitutional problem, and I hope you don't have any, then you should seek your own legal counsel. With these disclaimers out of the way, I'll move on. In the next 30 minutes, I would like to explore some of the chief constitutional protections the court has recognized as afforded to students, parents, and educators. These protections are particularly notable in the areas of equal protection and freedom of expression. While I will discuss some specific cases and we'll talk about the Supreme Court a great deal, I hope we can also take this opportunity to reflect upon how the structure of the Constitution itself works to protect our rights. I'll talk later about such interesting topics as banning library books and cursing cheerleaders. But first, I'd like to review a little history and political philosophy. More than simply setting forth a series of rights that have been expounded by the court, the Constitution frames a Republican form of government designed to protect liberty more generally. In that structure, education serves to protect the Constitution as much as the Constitution serves to protect education. Since we're supposed to be doing reading in the library, let us first look at the text of the Constitution. So what does the text of the Constitution specifically say about education? The short answer is that the Constitution does not expressly say anything about education. It is silent. If you read the entire Constitution on a sleepless night or do a word search on your computer through it, you will not find the word education anywhere. In contrast, other national constitutions, for example, the constitutions of France and Japan, refer specifically to the role of the state in education or refer to individual rights concerning education. Also, many state constitutions speak of education, notably the Constitution of Pennsylvania, which uses the word education or the word educational more than a dozen times. Despite the absence of any discussion of education in the Constitution, many of the framers were deeply concerned about education. George Washington, who presided over the Constitutional Convention in his first inauguration, urged the creation of a national university or the funding of existing private and religious institutions of education. He clearly viewed the promotion of education by this new national government as essential to protecting this new republic. I'd like to read for you what Washington said in his inaugural address, in part. Quote, "Knowledge is in every country the surest basis of public happiness. In one in which the measures of government receive their impressions so immediately from the sense of the community, as in ours, it is proportionally essential. To the security of a free constitution, it contributes in various ways, by convincing those who are entrusted with the public administration that every valuable end of government is best answered by the enlightened confidence of the people, and by teaching the people themselves to know and to value their own rights, to discern and provide against invasions of them, to distinguish between oppression and the necessary exercise of lawful authority, between burdens proceeding from a disregard of their convenience and those resulting from the inevitable exigencies of society, to discriminate the spirit of liberty from that of licentiousness, cherishing the first, avoiding the last, and uniting a speedy but temperate vigilance against encroachments with an inviolable respect to the laws." Close quote. This is a mouthful, even without false teeth. What I think Washington's words reflect is an understanding that education is important in protecting a Republican government. It helps those in government represent the people better, and is also essential for citizens to understand their own rights and know the difference between oppression on the one hand and the necessary work of government on the other. There is a strong sentiment that is important for democracy that citizens, through education, develop a respect for laws. So why is the word education missing from the Constitution? Put another way, if education was so important to the framers, why didn't the framers mention education in the Constitution? I think that despite the interest of Washington and other framers in promoting education at the federal level, the Constitution was more about this new federal government, and education at the time was viewed as a private or state concern. When ratified, the Constitution was seen as more about creating a more perfect union, and a national government of limited powers intended to improve upon the governance deficiencies of the Articles of Confederation, rather than an expression of specific rights enforceable by individuals. The structure of the Constitution itself protects rights, among other things, by creating a representative form of government and prohibiting any forms of nobility. Important to this structure is a system of separation of powers, federalism, and creation of an independent judiciary. These are all discussed in the Federalist Papers. As evidence of the point that education was a private or state concern, the 1776 Pennsylvania Constitution and other state constitutions predating and contemporaneous with the US Constitution had education clauses promoting education. For example, as the late David McCullough has observed, the Massachusetts Constitution, which was written by John Adams, states, quote, "Wisdom and knowledge, as well as virtue, diffused generally among the body of the people, being necessary for the preservation of their rights and liberties, it shall be the duty of legislatures and magistrates in all future periods of this Commonwealth to cherish the interests of literature and the sciences, and all seminaries of them, especially the University of Cambridge, public schools, and grammar schools in the towns." Close quote. What is the significance of this? Well, other than saying the Massachusetts legislature must cherish the University of Cambridge, that's Harvard especially, this language, like Washington's, recognized the importance of education to the protection of rights. This was something that is protected at the state level. Rights must be supported by a populace that has educated itself both to understand its own rights and to respect the rights of others. Once again, in 1789, this was very much a concern of the states and private institutions. But looking again further at the Constitution, what about the Bill of Rights? Does the Bill of Rights support education? The Bill of Rights was added to the Constitution, of course, as the first 10 amendments to the Constitution due to a concern at the ratification that the Constitution did not adequately limit the powers of the federal government. Some, such as Alexander Hamilton, did not believe the Bill of Rights was necessary. Most importantly, the Bill of Rights was not viewed as limiting the states in any respect. It was viewed as only limiting the federal government. Indeed, James Madison tried and failed to adopt additional provisions with the Bill of Rights that would apply certain restrictions on the states. The 10th Amendment itself states, quote, "The powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively or to the people." And of course, as I said, state constitutions have their own protections. Since the federal government was very small in the early republic, and the Bill of Rights was seen as only applying to the federal government, the Bill of Rights did not impact many people's lives in the way that people consider the Bill of Rights protecting them today. To quote the historian Gordon Wood, quote, "After ratification, most Americans promptly forgot about the first 10 amendments to the Constitution. The Bill of Rights remained judicially dormant until the 20th century," close quote. Of course, the lack of an education clause in the US Constitution is not the end of the story here. The importance of the Constitution and the Bill of Rights and its implication for the states and how rights are considered in educational institutions eventually changed following the Civil War. Following the Civil War, the 14th Amendment to the Constitution was added. I'd like to read you the language just so we can focus on it because it's so important. Notably, in part, the amendment states, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Perhaps the most profound expression of the changed view of the role the Constitution plays in protecting rights as a result of the 14th Amendment occurred in the case Brown versus Board of Education. This case is perhaps the most significant opinion, in my view, in the educational landscape and one of the most important cases of the Supreme Court. While the case was about education, it had profound impacts on all of society. In Brown, the Supreme Court overturned the doctrine of separate but equal, which had been previously established by Plessy versus Ferguson. If you read the short opinion in Brown, the court echoes the sentiments of the framers in talking about education. The court said, quote, "Today, education is perhaps the most important function of the state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate a recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in perpetuating him for later professional training, and in helping him to adjust normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms." Close quote. These are profound words. And so the right to equal protection in education is central to ensuring liberty in our society. We have seen the notion of equal protection expand to cases involving sex discrimination. United States versus Virginia, just as an example, decided in 1996, is a landmark case in which the Supreme Court of the United States struck down the longstanding male-only admission policy of the Virginia Military Institute. Also, I would point out in Pyler versus Doe, the Supreme Court held that a Texas law that prevented the enrollment of illegal aliens violated the 14th Amendment, as the court held illegal immigrants or illegal immigrant children are people in the ordinary sense of the term in the 14th Amendment, and therefore had protection from discrimination unless a substantial state interest could be shown to justify it. Although I don't have time to go into the details, following the 1960s, the Supreme Court has arguably limited the scope of its jurisprudence in the school equal protection area, and it has refused to intervene in other situations involving equal protection. For example, in 1972 in San Antonio versus Rodriguez, the court refused to intervene in a school funding case. Another example would be Milliken versus Bradley, a significant United States Supreme Court case dealing with the planned desegregation busing of public school students across district lines. Well, we've talked about equal protection. What about other rights in the educational sphere? Brown was preceded by many other important Supreme Court cases in following an understanding of applying the Constitution to the actions of state and local governments and protecting civil liberties. In other words, the new understanding of the 14th Amendment and the relationship between the federal and the state government. Beginning in the 1920s, a series of United States Supreme Court decisions interpreted the 14th Amendment to articulate substantive due process rights and later incorporate specific guarantees of the Bill of Rights, making these amendments enforceable against the state and local governments. One of the first landmark opinions in this new era was issued by the Supreme Court in 1923 in a case called Meyer versus Nebraska, which involved a challenge by a teacher to a Nebraska law that prohibited the teaching of foreign language in public or private schools. The Nebraska law had been passed during World War I, during a period of heightened anti-German sentiment. The court held that the law violated the Due Process Clause of the 14th Amendment. The court said about the 14th Amendment, quote, "While this court has not attempted to define with exactness the liberty thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, to establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men," close quote. The court found the restriction on the teaching of foreign language to be arbitrary and unconstitutional. A few years after Meyer, the Supreme Court decided the case of Pierce versus Society of Sisters. This is a case where the state of Oregon decided to amend its compulsory education laws to require all children to attend public schools. Religious schools challenged that requirement. The Supreme Court said, quote, "The fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and to prepare him for additional obligations." Commentators have described these cases as examples of the Supreme Court providing what has been called so-called substantive due process rights. Defining the contours of the substance of due process rights has been controversial. So the Supreme Court in more recent years has generally sought to ground constitutional protections in specific guarantees, most notably the First Amendment. From the 1920s to today, the First Amendment has proved to be a source of continued expansion of the understanding of liberty in the sphere of public education. In the 1940s, the Supreme Court decided West Virginia versus the State Board of Education versus Barnett. In 1942, the West Virginia Board of Education, in the middle of World War II, required public schools to include salutes to the flag by teachers and students as a mandatory part of school activities. The children in a family of Jehovah's Witnesses refused to perform the salute and were sent home from school. They were also threatened with reform school, and parents faced prosecution. In a 6-3 decision, the Supreme Court held that compelling public school children to salute the flag was unconstitutional. In an opinion written by Justice Robert Jackson, the court found the First Amendment prohibited the enforcement of such a requirement. In this opinion, we see a fulsome defense of the importance of intellectual freedom as a constitutional matter. Justice Jackson wrote, quote, "We apply the limitations of the Constitution with no fear that freedom to be intellectually and spiritually diverse, or even contrary, will disintegrate the social organization. We can have intellectual individualism and the rich cultural diversities that we owe to exceptional minds only at the price of occasional eccentricity and abnormal attitudes. When they are so harmless to others or to the state as those we deal with here, the price is not too great. But freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe which shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by words or acts their faith therein," close quote. This is a powerful statement of the essential notion, building on the other cases that I've just mentioned, that government should not interfere with intellectual freedom. Elsewhere in the opinion, Justice Jackson wrote more broadly concerning the Bill of Rights that, quote, "the very purpose of the Bill of Rights was, quote, to withdraw certain subjects from the vicissitudes of public controversy," close quote. This paradigm of removing certain subjects from the so-called vicissitudes of public controversy is perhaps at the heart of much of the latter cases involving civil liberties. Even from the beginning, though, legal commentators debated the merits of removing topics from the political arena. Notably, Justice Frankfurter filed a dissent in Barnett, stating in essence that by finding this particular law unconstitutional, the court usurped the role of the legislature in striking a balance between competing rights. He said famously, quote, "Our constant preoccupation with the constitutionality of legislation, rather than with its wisdom, tends to preoccupation of the American mind with a false value. The tendency of focusing attention on constitutionality is to make constitutionality synonymous with wisdom, to regard a law as all right if it is constitutional. Reliance for the most precious interests of civilization, therefore, must be found outside of their vindication in the courts of law. Only a persistent positive translation of the faith of a free society into the convictions and habits and actions of a community is the ultimate reliance against unbated temptations to fetter the human spirit," close quote. This last line is very interesting. What Justice Frankfurter is cautioning about is the notion that if we remove entirely the ability of citizens to learn for themselves about how to resolve these kind of disputes, we weaken the foundations of a republic. Judge Learned Hand expressed a similar sentiment when he said, quote, "I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes. Believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no court to save it," close quote. The debate over the extent to which the court should intervene in disputes over rights in the school setting or defer to local officials has continued to this date. The role of the Supreme Court in articulating students' rights was raised to a new level, perhaps in the 1960s. In Tinker versus Des Moines Independent Community School District, the court ruled in favor of two teenagers who wore black armbands to school to protest America's involvement in the Vietnam War. The court said famously in this case, quote, "First Amendment rights applied in light of the special characteristics of the school environment are available to teachers and students. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the Schoolhouse Gate, close quote. This is the case where the famous phrase Schoolhouse Gate comes from. And you can see in many works, and you can see this phrase in many works discussing rights in the school context. Rather than focusing on the Schoolhouse Gate, I find it more useful to consider the other part of this. I find it more important to consider another part of this quote in this case, that discusses the collision of rights and the need for school authorities to make rules. The court also said in this case, the court has repeatedly emphasized the need for affirming the comprehensive authority of the states and school officials consistent with fundamental constitutional safeguards to prescribe and to control conduct in the schools. Our problem lies in the area where students in the exercise of First Amendment rights collide with the rules of the school authorities. Finding consensus at this point of collision has not always been easy. While there seems to be consensus that education is essential for the development of civic virtue of the sort that is necessary for our democracy, there is a dispute over what fundamental rules should be made in a pluralistic society and who can make them in furtherance of education. The dissent in this case by Justice Black noted concerns with the role of the court. He said, quote, this court's holding in this case ushers in what I deem to be an entirely new era in which the power to control pupils by the elected officials of state-supported public schools in the United States is ultimately, in effect, transferred to the Supreme Court. One does not need to be a prophet or the son of a prophet to know after the court's holding today that some students in Iowa schools, and indeed all schools, will be ready, able, and willing to defy their teachers on practically all orders. This case, therefore, wholly without constitutional reasons, in my opinion, subjects all the public schools in the country to the whims and caprices of their loudest mouth, perhaps not their brightest students. I, for one, am not fully persuaded that school pupils are wise enough, even with this court's expert help from Washington, to run the 23,390 public school systems in our 50 states, close quote. So I've described cases that stand for equal protection, for the proposition that states cannot ban the teaching of certain subjects, that public school students have certain rights. What about other rights in the Constitution? I must note that not all constitutional rights have been applied to students. For example, in Ingram versus Wright, decided in 1977, the Supreme Court upheld the disciplinary corporal punishment policy of Florida's public schools by a 5-4 vote. That was paddling in this instance. The court held that such corporal punishments did not violate the Constitution's ban on cruel and unusual punishments, unless the punishments were, quote, degrading or unduly severe, close quote. This is, of course, the constitutional floor set by the Supreme Court. So before any of you get out your spanking paddles, I should note that corporal punishment is not allowed in Pennsylvania schools, according to the Pennsylvania Code. What about library books? Since my talk is sponsored by the state library, I should mention an important case involving school libraries. In Island Trees School District versus Pico, a plurality of the Supreme Court held that the First Amendment limits the power of school officials to remove books from school libraries because of their content. In 1975, a New York school board received a complaint from a group of parents. The complaint asserted that school policies on library books were too permissive. Specifically, the parent group complained about 9 books, including Kurt Vonnegut's Slaughterhouse-Five. The group said the books were, quote, anti-American, anti-Christian, anti-Semitic, and just plain filthy, close quote. In response, the school district removed the books. 5 students challenged the school board's decision to remove the books. The Supreme Court plurality ruled in the students' favor on First Amendment grounds, holding that local school boards may not remove books from school library shelves simply because they dislike the ideas contained in those books. The decisions called libraries places for, quote, voluntary inquiry, close quote, and concluded that the school board's absolute discretion over the classroom did not extend to the library for that reason. Justice Brennan tied his ruling to what he described as a right to access to information. Quote, in sum, just as access to ideas makes it possible for citizens generally to exercise their rights of free speech and press in a meaningful manner, such access prepares students for active and effective participation in the pluralistic, often contentious society in which they will soon be adult members, close quote. A dissent in the case argued that the decision was one that should be made by the school board, which was ultimately accountable to voters. And so the debate continues over the power of local school boards to make decisions in the educational sphere when it may impact civil rights. Just last year, the Supreme Court decided a case from a Pennsylvania school district, Mahoney Area versus School District versus BL, which some have referred to as the cursing cheerleader case. In that case, a student at Mahoney Area School tried out and failed to make her high school's varsity cheerleading team, making instead only the junior varsity team. Over a weekend away from school, she posted a picture of herself on Snapchat with the caption, and I'm going to omit the expletives, blank school, blank softball, blank cheer, blank everything. Several students who saw the captioned photo approached the coach and expressed concern that the snap was inappropriate. The coaches decided the student's snap violated team and school rules, which the student had acknowledged before joining the team, and she was suspended from the junior varsity team for a year. The case went up to the Supreme Court, and the court found in an 8-to-1 opinion that the First Amendment limits, but does not entirely prohibit, regulation of off-campus speech by public school officials. And in this case, the school district's decision to suspend the student from the cheerleading team for posting to school media, social media, vulgar language and gestures critical of the school violates the First Amendment. Outside of the area of student speech, there's been continued litigation involving the sometimes competing interests between religious freedom at schools and non-establishment. In the 1960s, the Supreme Court decided a number of cases and created a test known as the Lement Test to determine whether a state action violated the First Amendment's prohibition on state establishment of religion. The applicability of this test appears to be in decline. In just the past term, the Supreme Court has ruled in 2 cases involving religion in schools. In a case from Maine called Carson versus Mackin, the Supreme Court ruled that if Maine created a program to support private schools, it could not exclude religious schools from that program. In another recent case, Kennedy versus Bremerton School District, the court ruled that a high school football coach could not be disciplined by his by a school district for engaging in prayers on the field. Interestingly, in this case, there was a dispute over how the facts of this case should be characterized. The majority ruling believed the prayer exercised was in a private moment and did not reflect the school endorsing religion. As the court said, quote, the Constitution and the best of our traditions counsel mutual respect and tolerance, not censorship and suppression for religious and non-religious views alike, close quote. The dissenters very much disagreed with that characterization and included pictures of the prayers on the field with many players gathered around. In dissent, Justice Sotomayor also wrote that the Supreme Court, quote, has consistently recognized that school officials leading prayer is constitutionally impermissible. She said, she went on to say that the majority ruling, quote, charts a different path, yet again, paying almost exclusive attention to the free exercise clause's protection for individual religious exercises, while giving short shrift to the Establishment Clause's prohibition on state establishment of religion. So we've had today a quick sketch concerning the Constitution and some important cases. It seems fitting to celebrate with the library these cases and the protections that the Constitution provides us all. At the same time, as I have emphasized from the beginning, the Constitution was framed as more than simply a bill of particular rights to be enforced by judges. The Constitution frames a government that protects our multitude of rights by mechanisms that include a limited federal government, a role for state government, and state constitutions that promote education. I reviewed the long history of agreement among the framers in the Supreme Court that learning is essential to protect Republican government. Schools and libraries nurture citizenship. Again, as noted by David McCullough, John Adams once wrote, quote, "I must judge for myself, but how can I judge? How can any man judge unless his mind has been opened and enlarged by reading?" Close quote. Education serves to protect the Constitution as much as the Constitution serves to protect education. I'd like to conclude by again thanking the State Library for this opportunity to speak to you today. I look forward to answering a few questions, and it looks like many good ones have been submitted to me in advance. Thank you very much.
Thank you very much, Patrick. Ellen Schenk, would you see if there's any of the questions that we can get started on?
Sure. I'm going to start with the ones that were added to the meeting chat today. So if anybody has any questions, please feel free to add them to the chat here. The first I see is, I find it to be surprisingly short, mainly defining the structure of the federal government and laying out the foundation for statutes based upon our shared values and principles.
In answer to that, I would say I agree with you. I mean, I think that, especially before the 14th Amendment, the Constitution can be seen really as setting forth a very set of limited powers for the federal government. And I think it's really, as I said in my talk, I think it's only with the 14th Amendment that you see a new understanding of the Bill of Rights as applying to restricting the actions of the states. And so, I think in the historical context, I think, as I said, I think the framers believed education was very important, but I think that they very much expected that it would be largely dealt with at the state and local level, and I think there was a very large role to be played by the state. I think I would have to recognize, though, at the same time, I mean, Washington and others really felt that education was something that the federal government could exercise its, if you will, authority over in some capacity. And from the very beginning of the Republic, there were efforts to fund education. So I think you're right. The Constitution doesn't really say very much about education. It's only later that we have this new understanding.
I also put something in the chat that says that the Constitution was really made to be an ever-evolving document, a living document of our country as it expanded, so that what the founding fathers thought was important, they knew would evolve into other areas as the country grew. Plus, there was a lot of discussion between the rights of the federal government versus the rights of the states and how that could meld together.
Yeah, I mean, I think in this talk, I've sort of tried to avoid like a debate over, how one should necessarily interpret the Constitution, and so, but I think it's, if you just simply look at the text of, I think if you simply look at the text of the language of the Constitution, I think that says a great deal, and I think as an element of legality, that's the important aspect of the Constitution, that it is a written document. But again, I think as lawyers, we understand there's a text, and ultimately the Supreme Court ultimately has the final say, and so that's why I think it's important to first understand the text, and then before you look at what the Supreme Court has said. And as you can see from my discussion, over time, those rulings have changed, and the religion, the sort of free exercise of religion versus the establishment view of the First Amendment is a current example where there's a lot of change, I think, in how the Supreme Court has viewed the very text that we're dealing with.
I've also put into the chat a link to Constitution Day so that when you have a night that you really want some exciting reading, you can go and read the Constitution right off of the Constitution Day website.
Okay, Mariah asks, do you think the burden is on biggest on Pennsylvania since the Constitution was written there? Any thoughts?
Well, I mean, I think we can. I think we can take pride that the Constitutional Convention occurred here. As Kathy said, that so many prominent Pennsylvanians were part of that discussion, and I think we have a wonderful Constitution Center here in Pennsylvania. Those are all things really I think that are worth celebrating. It's part of our wonderful heritage.
I think too, sorry, one more thing, Ellen. I think that Pennsylvania knows that it is part of not of the United States as a whole, so that they have been at the front of many of the efforts for education throughout the country.
Could you explain?
I definitely agree. I think Pennsylvania has a very proud tradition, both with the U.S. Constitution. We have a very going back to William Penn, a great history of respect for rights in the state, and some of the most important debates about the educational issues, the Constitution, have occurred in Pennsylvania.
What's next, Ellen?
Could you explain the 14th Amendment to the U.S. Constitution with regard to Brown versus Board of Education and foreign students within the jurisdiction of the United States?
Sure. Yeah. So I think I sort of briefly touched this case, Tyler versus Doe, which was a 5-4 decision actually by the Supreme Court, which held that the children that happened to be illegal aliens were persons within the meaning of the 14th Amendment. And so at that time, the state of Texas had passed a law that wouldn't fund education or wouldn't enroll those children. The Supreme Court narrowly found that that was against the 14th Amendment. And so that case is still very much the law of the land. You may have seen in the media that at least in light of recent decisions by the Supreme Court overturning other decisions, there's some people who would like to see that case challenged.
And there's been a lot of court cases in state Supreme Courts. One of the most famous is out in California of Tate versus Hurley in 1885, where a Chinese American family sued the school district to allow their children to attend public school. Is there other questions, Ellen?
Yep. Please address the movement to use school taxes for non-public schools, i.e. the money follows the child.
Well, I think that's a pretty big topic. I think because just speaking about the U.S. Constitution, I think for many years there was a lot of litigation over whether the use of money, public money, to sectarian schools would violate the U.S. Constitution. And I think the case that I mentioned from Maine in the last term, I think at least the current ruling of the Supreme Court would say that that's not really a U.S. constitutional issue any longer. I mean, in other words, states are free to do that. However, I think what states cannot do, according to that opinion, is decide to just, if it decides that it's not required to fund non-public schools, but if it decides to do so, it can't not have sectarian schools be part of that program, according to the Supreme Court. but that like, what the case didn't really address, or what might be other limitations in state constitutions concerning the use of public money for private schools. So I think that issue is still very much open. I would also say sort of the issues of funding really are tend to have to be sort of state based and state constitution based. I hope that answers your question.
Thank you. Another, are teachers still allowed to do the Pledge of Allegiance to the flag or no?
Well, I'd say that consult your legal counsel. I mean, I think that the Supreme Court really had to do not with whether a teacher was permitted to do it, but was whether students could be forced to do it. So I think the Supreme Court case is pretty clear that that students can't be forced to do the Pledge of Allegiance. But in terms of what a teacher is allowed to do, I mean, they really should talk to their school district about that. So there's been, the initial litigation, in the 1940s was really about forcing students to, do the Pledge of Allegiance, swear to the flag. That was, people have the right to dissent from that. Students have the right to dissent from that. In recent years, there's been some controversy. I don't think it's been finally resolved concerning whether, like, the "In God We Trust" type language under God in the Pledge of Allegiance is something that people can be required to do, and that's sort of why I think I would direct a teacher to their local school, their district, to decide whether that's something they should be doing.
Todd asks in the chat, you noted that the framers intended for most educational decisions to be made at the state and local levels. Do you think the U.S. Department of Education has gained power over many school districts because of its grants and other funding mechanisms to local schools?
Well, I mean, I think that's an interesting observation, because I think, as I said, I do think that the original understanding of the Constitution was, as I said, that it was really going to be a state and local role. I think the issue really is, with the 14th Amendment, what powers are appropriate for the federal government to exercise. I think many people see the powers of the federal government exercised through various federal laws as stemming from the 14th Amendment. You'll often hear, the No Child Left Behind law, ESSA, all those federal laws, the grant programs being referred to as important civil rights legislation. So, I mean, I think there's different bases to justify it, but I think you'd have many people say that despite what it may have been the original understanding, because of the importance of civil rights, that all these programs are necessary, and that's where that would come from.
Lysandra says, PA congratulatio, I don't know what that is, has an educational right. How do you think the chances that the funding education lawsuit will have?
Yeah, that I definitely can't comment on the school funding lawsuit because we're a party to that. So I'm afraid I'm going to have to not answer that one.
What is the legal basis for the U.S. to create the Department of Education? Wouldn't the 10th Amendment to the U.S. Constitution leave that power with the state level departments of education?
Yeah, again, so I think that that's a very interesting point. I think as I said, I think the original understanding of the Constitution was that education would be left predominantly to the states. Although at the same time, the very first item on George Washington's agenda, the first president, he'd been at the Constitutional Convention, was a desire for the federal government to fund a national university or fund religious institutions through the federal government. So I think from the very beginning, there was a feeling that maybe, despite the structure of the Constitution, whether it be through the spending power, the necessary and proper interstate commerce power, that if the federal government deemed it to do so, it could do so. Now, historically, the state and local governments have had the predominant role. I think if you look at the legislation setting up the Department of Education in the late 1970s, or that, you know, the legislation itself sort of said, recognized the primary role that the states were supposed to play, and also said that they weren't, expressed the desire not to interfere with their power. You know, I think it was the language of that legislation says that, you know, in order to address poverty in the country, these programs would be funded and promote the general welfare. So I think that's sort of, I can't speak for the U.S. Department of Education, but I think that's sort of where you see them coming from there on that. And again, it goes back to what I said about, I think, you know, with the 14th Amendment to the Constitution, the text of the Constitution is obviously very different.
Can you walk us through education cases that follow the theme of how we understand positive and negative liberties? How do we balance government promoting the common good with ensuring government doesn't strip people of individual liberties? Masks in school might be an example of that push and pull, or maybe something a little less controversial like paying a local school tax.
Well, I mean, I think without commenting on the specific situations, I think the theme that I've tried to draw today is that it's certainly important to recognize that there are certain rights that we have in the Constitution that we can go to court to enforce. But I think it's equally important to understand that to survive as a democracy, that we need to promote education. And I think we also need to promote ways of working through these difficult controversies involving rights. I mean, we can't expect the courts to resolve every issue. They're not set up to do that. But also, I think it's really, I mean, is what Tocqueville said, habits of the human heart, or how you get accustomed to working through these issues. You know, George Washington himself said the point of education, and just sort of paraphrasing, was so that people learn the difference between oppression and the necessary operation of government. It's through that education, but it's important for the people who are to be leaders to understand the importance of gaining the respect of people who they're seeking to lead. So you know, in that, you know, it seems to me that you know, just because you have the power to do something doesn't mean that you should do it as an official. And having a respect for other people's rights and interests is so important. I think understanding that dynamic is probably even more important than understanding your constitutional rights.
Lysandra added, with a conservative court, do you see a tightening of the 14th Amendment? Do you think Brown or Plyler can be overturned?
Well, again, I'm just speaking for myself. I think that I don't think you see any of the Supreme Court justices talking about overturning Brown. And I think that, in fact, I mean, it seems to be one that is almost universally recognized as being. Plyler, I think maybe, you know, I don't think I've seen the current Supreme Court. I don't recall whether any of the current Supreme Court justices have questioned it. I think it's probably that may be a closer issue. I think that, you know, it's interesting because I think you see the Supreme Court in some areas, for example, religious freedom and the First Amendment being very, very active. So the only way that they applied, I mean, essentially the way that that one has equal protections against encroachment for religion or for the First Amendment in speech is through the 14th Amendment. So, it may be a question of them encroaching the 14th Amendment in some areas, but not other areas. But by and large, I don't think the court is turning back from the notion that there are many important rights in the Bill of Rights that are incorporated through the 14th Amendment and applicable to the states through that doctrine of incorporation. I don't see them backing away from that. I don't see them backing away from Brown versus Education, but some things in terms of whether, Pilot versus Doe right now is the law of land, whether that will be, continued if Texas challenges it through the courts, I just don't know.
Okay, there's another one here. In your opinion, what are the dangers you see in our country's current atmosphere of anti-intellectualism? And how can we as educators promote learning to the next generation?
Yeah, well, so again, I'm gonna go back to George Washington. It seems to me that George Washington was really onto something about education, and I think starting with, I think someone works in state government, I would say, for us who are working as employees, and for, I would say, to state officials, it's part of making a working society is developing trust with people. And that's an important element of education, learning about rights. So it starts with that, but I think promoting education so that that people understand, the difference between what's really a true encroachment on their liberty and as George Washington would say, sort of an inconvenience. Those are things that one develops through through education. And, I think there's something to learn and hand sentiment about liberty being in the hearts of people, habits of the heart through daily interactions with people, resolving our disputes ourselves. Even we have a system of local control, allowing people to work through some of these problems without always going to court helps build more working systems for people. So I think, over time, we've been through a lot of periods where, there have been concerns for, the Red Scare in the 1950s as being just one example where people felt that there was a real infringement of First Amendment rights. And I think people said that was anti-intellectualism. I think the solution to that is in part the courts, but I think it's also us as citizens in trying to work through our disputes and having respect for other people's rights. And Warren had also said, liberty is a spirit. I'm paraphrasing, not always being sure that you're right. And I think there's that very strong element about not always pushing your authority and trying to compromise with people and working through issues.
Okay, thank you everybody for participating today in our National Constitution Day. We only have about a minute left before we are done for the day. Thank you, Patrick, for being part of this brainchild that we want to celebrate the U.S. Constitution. It's also, as Patrick mentioned, it's National Banned Book Week, so make sure you go out and read a banned book. Also, today is Batman Day, so make sure you go out and read a comic book. There's lots of things at the state library and your other libraries throughout the state for you to be a lifelong learner, which is one of the missions of not only the state library, but the Pennsylvania Department of Education. So thank you once again, Patrick and Ellen and Nicole McCune and Bill Fee as part of the state library staff for being part of this today. You can see a recording of this on the state library's website under Lunch and Learn after we've gone through and gotten the okay to put it on there. So it should be just a day or two before that's put up. So if you have other people that would like to hear this and could not be part of this today, it will be on the State Library's website. So thanks very much, everybody, for coming today.
Thank you.